Hey, Apple Canyon, it is your favorite dude from the Uncensored page, Sean Cottrell, and I've got a doozy for you today. Let me just go ahead and share my screen and we can dive right into this. But today I want to talk about transparency of operations at Apple Canyon Lake. I'm going to move my head to this top right corner up here. And let's go into it, right? So what is transparency? And no, I don't mean, Jeffrey Tambor's or Amazon original. I mean transparent governance. Transparency is the principle of allowing those affected by administrative decisions to know about the resulting facts and figures, like the Apple Canyon Lake budget, and about the process that resulted in those decisions. What sort of information was contemplated before, like, we decided to do this thing, right? Transparent governance means that elected officials act openly with members' knowledge of the decisions that those officials are making. So again, there's not like secret meetings. Things are available, right? It's very easy to understand how decisions are made, why they're made, and what information supports those decisions. Availability of information on policies and actions, a clear sense of organizational responsibility, and an assurance that associations are efficiently administered and free of systemic corruption are important components of transparent governance. So how is ACL transparent? And let me actually correct this, right? How is ACL supposed to be transparent? Our governing documents identify processes that create transparency. Illinois law require transparency for homeowners associations, and we'll cover that. And members expect it to happen, right? No one wants to live in the dark. We all pay money to be part of this community, right? We all pay our annual dues, we pay our taxes, we have our beautiful houses, our beautiful properties, we love to enjoy the amenities, but we want to know like how our money's being spent if we can't enjoy those amenities, and that seems to be a lot of the conversations that are going on today, especially in social media, when bumping into people on the trails, when we're all out and about talking and everything like that. So let's really dive into today's conversation. And let's really focus on Apple Canyon Lake's governing documents. The first document that I really want to talk about is the bylaws. And I'm really going to focus on that because that's really what sort of sets the transparency precedent around board meetings at Apple Canyon Lake. So Article 9 specifically addresses board meetings of the amended and restated bylaws. And, sections 1 and 2 here, right? Our bylaws contemplate two different types of meetings, having a regular meeting and having a special meeting. There's also notice requirements. There's notice requirements for board directors as well as for members. And there's methods of notice. And then there's also meetings that are open to the members. So we're going to focus on those. And I'm actually going to go right into the bylaws. And let's just take a look at this. So I'm in the bylaws. I'm in Article 9, the board meetings. And, we see regular meetings and special meetings, and those are defined, there's supposed to be 4 regular meetings, not less than 4 regular meetings each year. And when we look at special meetings of the board can be called by the president, by at least 25% of the members of the board, or upon the request of 50 or more votes of the voting members. So again, like there's many ways for a special meeting to sort of come about. And you might already know where I'm getting at, but maybe not. I'm hoping this is going to be pretty straightforward. So section 3, notice of special meetings and all meetings concerning budget matters. All special meetings of the board shall be held only after notice has been given to all members of the board, all voting members and all owners at least 30 days, but not more than 60 days prior to such a meeting. So we see that there's these notice requirements that are built in here. However, if a majority of the members of the board determine that a special meeting of the board must be held on an expedited schedule, notice of such meeting may be given to all voting members by any means practicable within at least 48 hours, but not more than 10 days prior to such a meeting. And we also see this area that I highlighted in red or underlined in red, and I'll kind of position this like this. Notice of a special meeting of the board on an expedited schedule may be by posting notice on the association website, using any telephonic or electronic communication device, and by posting notice at the clubhouse and other conspicuous places on the common properties, and by U.S. mail postage prepaid if time permits. So, again, like it seems pretty straightforward. Notice how nothing in here says, by posting on the association website or using any telephonic or electronic communication device, or by posting notice at the clubhouse or conspicuous places, right? It says these are the ways that the notice of a special meeting must be given. Methods for notice, right? So section 4 really talks about notice of any special meeting of the board or of any regular meeting of the board at which budget matters may be acted on. And this is an area where it kind of talks about what some of those topics would be. I'm sorry, this is what talks about those methods for providing notice. Notice of such meetings shall be provided to all voting members and all other owners for publication in the Apple Core and on the association's website and by posting notice at the clubhouse. So that seems pretty straightforward, right? That we have this transparency built into the bylaws. When I scroll down further, we also see that last section, section 8, meetings open to members. All regular and special meetings of the board shall be open to all members. All association business is to be conducted at open meetings, except when the board determines in its discretion to meet in executive session, either associated with a noticed meeting or separately from a noticed meeting. Well, that's pretty straightforward. They can either meet under a noticed meeting or from outside separately from a noticed meeting. Also in the bylaws here, and actually let me scroll it just a little bit, there are 6 sort of topic areas where the board can choose to meet in closed session. And that's, discussing litigation, third-party contracts or employment issues, interviewing employees, violations of the association's rules and regulations, consulting with the association's legal counsel. So that seems pretty straightforward, right? If any one of these 6 topics is discussed, then the board can have a meeting that does not need to be noticed because they can meet separately from a noticed meeting. So pretty straightforward. All executive session meetings shall be held in the association clubhouse. Okay, straightforward, right? Not a big deal. Any vote on these matters shall be taken at a meeting or a portion thereof open to a member. So that's like why, when we look at the how the board conducts its business, when we look at the minutes, we do see in there that there's like the executive session minutes and things like that. When we think about any vote on these matters, like at the last board meeting that was recorded, right, you guys can actually watch it. That's on the website like right now. The board like says we're going to go into closed session. And like they walked out of the meeting into another room and they heard an appeal from a property owner according to the appeals process. They heard everything, they had some discussion, things like that. And then they came back in and then they held the vote, like when they were back in the board meeting, right? So they met in closed session to have that discussion. And there was a property owner that was present because of the appeals process. And then again, they came back into the board meeting to have that vote. So let me get back into the PowerPoint here, right? So things are pretty straightforward, right? And so that's what the bylaws say. And where do those requirements come from? Well, we look at SECA, right? SECA is the Common Interest Community Association Act. And when we look at section 1-40, meetings B4, we see that except to the extent otherwise provided by this act, the board shall give the members notice of all board meetings at least 48 hours prior to the meeting by sending notice by using a prescribed delivery method or by posting copies of the notice of meetings on entranceways, yada, yada, right? So, okay, 48-hour notice when we have that notice requirement. But SECA also has this additional portion right here. Oops, I gotta move my camera or my video bubble because I just wanna make sure I'm not blocking anything. So when we look at the next section, so this is B4, and when we look at B5, we see that meetings of the board shall be open to any unit owner, except that the board may close any portion of the noticed meeting or meet separately from a noticed meeting. Well, that like mirrors exactly what we just saw in the bylaws, right? We see that meetings of the board shall be open to any units, except that the board may close a portion of a noticed meeting or meet separately from a noticed meeting. Well, we know that the board sort of did this, like they closed a portion of the last board meeting with that example I just shared. And it sounds like they can also meet separately from a noticed meeting under SECA. Well, that's pretty straightforward, right? I think that's squared away. The board can choose to meet an executive session without notifying members. But I think you know me a little bit better than that. And unfortunately, I like to do my homework. And before I quote on any laws or put together a PowerPoint presentation that I'm going to share by, social media and record on, put on my YouTube channel, I really like to educate myself on how did we get here, right? So first, I like looking at the structure of an organization. And Apple Canyon Lake is a corporation. We know this, right? We can look at the articles of incorporation. The name of the corporation is the Apple Canyon Lake Property Owners Association. We see that it was incorporated on May 6th of 1969. And the corporation is a homeowner association, which administers a common interest community as defined in subsection C of the Illinois Code of Civil Procedure and under SECA. Well, that's pretty straightforward, right? Let's dive in a little bit further. Apple Canyon Lake isn't just a homeowners association in the state of Illinois, but Apple Canyon Lake enjoys not-for-profit status due to the way that it was organized and the way that it was incorporated. So ACL is an Illinois not-for-profit corporation, and that's why the Illinois Not-for-Profit Corporation Act is listed second on the governing documents page on our website. And the Not-for-Profit Corporation Act is a law that ACL is required to adhere to, which imposes additional restrictions on the conduct of business on behalf of the association's members, right? Like if you are a not-for-profit corporation, you have a different set of rules because this law exists, right? So really quickly, I do want to just dive into the website real quick because I know sometimes people ask like, where are these documents and how am I even aware that like the Not-for-Profit Corporation Act is like something that Apple Canyon Lake has to abide by, right? Well, when I go to the website and I click on that governance tab and I go to governing documents and I scroll down, I see the documents that are in our governing body. This is our body of governance. And I see first here SECA. Well, I've mentioned that a few times already on this video. And next I see the Illinois Not-for-Profit Corporation Act. Oh, well, pretty straightforward, right? Like it wasn't difficult for me to find like where this law is. It's not like it was hidden anywhere. We'll get into that in a moment. All right, so ACL is a not-for-profit corporation. So what does that Not-for-Profit Corporation Act say about transparency? When we look at Article 8 of the General Not-for-Profit Corporation Act of 1986, Article 8 covers directors and officers. And when we look at Section 108.21, we see that meetings of the board of directors of a not-for-profit homeowners association or residential cooperative not-for-profit corporation shall be open to any member except for the portion of any meeting held to discuss litigation, to consider information regarding appointment, employees, to discuss violations of the rules. This also says any member may record by tape, film, or other means the proceedings. The board may prescribe reasonable rules, and that's why like we have that policy in place right now, right? The board has those rules for how well, actually, no, it's because they maintain it, right? They're actually not permitting people to record it. But I think sometimes you can click record and Sean Nordley gets a prompt and he just has to accept that prompt. So if you ever are trying to record from one of the Zoom meetings, make sure that you just click that record. And if you don't see the record button light up and you don't hear that recording start, just unmute your mic and say, hey, who's the host of this meeting? Can you accept my request that I could record this on my local computer? Because that's generally what I do for board meetings, and that's why I have copies of the board meetings. Yeah, I've raised a big issue with this only keeping those recordings for 25 days, and I'm hoping it goes longer. And I'm really hoping that that's going to be on the agenda for the next board of directors meeting. But what I would really like to do right now is actually look back at SECA. And I'd really like to look at that section in SECA that talks about meetings of the board of directors and the section under the Illinois Not-for-Profit Corporation Act, 1986. So when we look at SECA, and that's on my left side of my screen, we see meetings of the board. And this was what I just had in that PowerPoint presentation, but I wanted to put it side by side because it's glaringly obvious to me. So I don't know how it's like so easy to miss, like when business is actually trying to be conducted on behalf of the association. Like some of this stuff is just like how is the ship even still running like at this point in time? Like it's held together with shoestrings and toothpaste or something. So anyways, meetings of the board shall be open to any unit owner except that the board may close any portion of the notice meeting or meet separately from a noticed meeting. Now when we look, because remember, we're not only accountable to SECA, We actually have a stricter law that we have to comply with because we are a not-for-profit homeowners association. Meetings of the board of directors of a not-for-profit homeowners association or residential cooperative not-for-profit shall be open to any member except for the portion of any meeting held to discuss, and then those topics fall. So you'll notice the section here that I underlined in red, or meet separately from a noticed meeting, is not an option that is available to the Apple Canyon Lake Board of Directors because they are a not-for-profit homeowners association. Notice for such meetings shall be mailed or delivered at least 48 hours prior thereto, unless a written waiver or such notice is signed by the person or persons entitled to such notice pursuant to articles of incorporation. Copies of notices of meetings of the board of directors shall be posted in entranceways, elevators, and other conspicuous places at least 48 hours prior to the meeting of the board of directors. So it seems pretty straightforward that, like the board can't just say, oh, we posted it on the door and that was good enough, because they only satisfied one of these requirements. They did not satisfy the requirement of providing notice to the members before the 48 hours. I know, again, that I did not receive an email. I did not receive anything mailed to my residence, actually to any of the residences that Apple Canyon Lake has on file for me. And so that's kind of concerning, right? And just to clarify even further, under the Illinois Not-for-Profit Corporation Act, for purposes of this section, meeting of the board of directors means any gathering of a quorum of the members of the board of directors held for the purpose of discussing business of the homeowners association or cooperative. Anytime there's a gathering of a quorum, it does not say in person, face to face. It does not exclude or preclude electronic meetings. So if we had a Zoom meeting, if I was on the board and we had the board of directors had a Zoom meeting, that's a meeting that would require notice under the Illinois Not-for-Profit Corporation Act. I mean, that's pretty straightforward. I mean, like, it's literally on the screen. You can argue with me all you want, but realistically, you'd be arguing in court, right? Because, I mean, that's where you would argue, like, when the law is applicable. So let's get back into the PowerPoint. So pretty straightforward, right? The board cannot meet outside of a noticed meeting. They are only permitted to close a portion of that meeting, like they did at the last board of directors meeting. Again, it's like sometimes they do this sort of thing. Sometimes. So what's the purpose for this whole meeting or for this whole video? And I know I'm like 16 minutes in. I started my timer like on time this time. I'm really proud of myself. We know that on December 2nd, the Apple Canyon Lake Board of Directors met with attorneys from Key and Costello, Keith Jones, and Doug Surrey. No notice was given to members that the meeting was happening, even though it involved more than a quorum of board members. Legal committee members who brought these issues to light were not notified of the meeting. I am the new chair of the Apple Canyon Lake Legal Commission, and I didn't even know. We had a legal committee meeting that afternoon, and it was just sort of communicated in passing that there was this meeting with Key and Costello or meeting between Key and Costello and the board. We weren't invited to provide any of the evidence that we found. I mean, again, everything that was brought to the legal commission and shared with the membership, that's what brought the vote on the declarations to an end, right? It was the chair of the legal commission, Dave Allgood at the time, who moved to stop the vote on the declarations and to cancel all those votes. No minutes from this meeting on December 2nd have been posted to the Apple Canyon Lake website as of 5:20 p.m. Central Standard Time, and I believe it's the 10th. I'll double check that. Yeah, Friday, December 10th, right? The Apple Canyon Lake Legal Committee has come to understand that the discussion was regarding the vote on the declarations that was stopped. The vote on the bylaws was also discussed, and Key and Costello were asked to provide recommendations on the board of to the board of directors on how to proceed forwards with the bylaws. I'm really going to get into this in a second. During the meeting, it appears, oops, I got a typo there. I should fix that right away. During the meeting, it appears that Key and Costello advised the board that unless someone can prove there was fraud in the conduct of the vote on the bylaws, there is no fraud. Now, I chose not to go into what it constitutes fraud in the state of Illinois in this video, but if that's something you guys want, drop it in the comments once I post this on the Uncensored page. Happy to dive into that one, but I mean, seriously, how many layers of this onion do we have to unpeel before we're going to say like, hey, my eyes are watering, it smells like an onion here, right? So, I raised this issue about the bylaws, right? What do we know about the vote on the bylaws? The ACL Tellers Committee guidelines were not used to conduct the vote on the bylaws. If you have any questions about this slide in general, go watch my video about the Tellers Commission. The procedure to conduct the vote on the bylaws was never approved by the ACL Board of Directors. Our governing documents, our bylaws, require that any process or guidelines used to count ballots for any vote at Apple Canyon Lake be approved by the Board of Directors, right? Like there's like an official process to all these things. And we know for a fact that the procedure to conduct the vote or to count the votes for the bylaws was never presented to the board for approval. Just didn't happen, right? I mean, again, if someone has like something that's hidden and I'm not aware of it, but I've gone through all the meeting minutes, I've gone through all the agendas, I've gone through all of the memos documents. I can't find it, and I've been asking for it, and I haven't gotten it to this point, and that's why I'm making a video on this. When the ACL Tellers Committee was engaged to count the vote for the bylaws, they received tampered ballot envelopes to count. And what do I mean when I say tampered ballot envelopes? The ballot envelopes were already opened, and the Tellers Committee guidelines indicate that if opened ballot envelopes are given to the Tellers Committee to count, these votes are not to be counted and are supposed to be just returned to the general manager. That's it. They don't count towards a yes or a no. If the Tellers Committee gets a ballot envelope that's opened, that's disqualified. So let me summarize what I went through. Thanks for sticking with me if you're still here. We're 20 minutes in. I'm going to wrap it up real quick. The secret meeting between the Apple Canyon Lake Board of Directors and ACL Legal Counsel, Keith Jones and Doug Surrey from Key and Costello, appears to have violated notice requirements of the Illinois Not-for-Profit Corporation Act. Watch the video again if you still have questions on that, or drop a question in the chat. Definitely happy to answer. The tainted vote on the bylaws used the same process that was used on the declarations. How can we have any trust in the process if we still don't know what the process was, right? Like, I mean, I would love to consider that, like, yeah, 900 people voted for the bylaws, right, in total. I don't remember exactly how many yays or nays there were. I didn't prepare myself for that for this video. But like there was a lot of interest in it, right? I mean, like that's pretty concerning if that's in question. We know that the Tellers Committee guidelines were not used. If they were used, that would result in all ballots that were delivered to the Tellers Committee for counting to be disqualified because the ballot envelopes were opened by other than the Tellers Committee. It's straightforward. We also know that ACL governing documents require that the process used at Apple Canyon Lake to count any votes of the membership to be approved by the board of directors. And again, if you have questions on that stuff, watch that Tellers Committee guideline or that Tellers Committee video that I did. Watch that quorum video that I did. I mean, it's pretty straightforward that the rules were not followed here for either of these votes, and that's very concerning. So I'm going to wrap it up here. Again, thank you guys very much for sticking with me. There's going to be more to come on this specific topic. This is going to be part one of my first ever two-part series. I will follow up once more information comes out on what was discussed in that December 2nd meeting with Keith Jones and Doug Surrey from Key and Costello on who called the secret meeting between Key and Costello and the ACL Board of Directors, because I think that's interesting. Did the person who actually requested and recommended and called that meeting to order just decide like not like where do these laws sort of come in? Like this is so it's boggles my mind. Again, it's just like it's so concerning that like these very simple things aren't being captured, and like our legal counsel is involved every step of this way. And why this meeting was called without a notice to the membership, I mean, that's very concerning. There's a lot of people who are paying attention to this issue with already ending the vote on the declarations and already being concerned that, like, the new bylaws that potentially were voted in February have conflicting portions in there. So even if those were able to be approved, technically they don't match to the corresponding to the correct corresponding parts of the declaration. So if the bylaws like would have to be approved, or if it were to be approved, they would need to almost immediately be amended. Like it doesn't. I'm very interested to see which direction Kean Costello is going to come back when they make the recommendations to the board, or if that's really what they were charged with doing. Furthermore, knowing that that meeting was held on December 2nd, and being the chair of the legal commission, I know that meeting minutes need to be posted 10 days after the meeting. So I'm looking forwards to reviewing the meeting minutes from that meeting. Anyways, I will wrap it up there. Thank you very much for hanging around. Ooh, 25 minutes, probably a really long video, but anyways, stay frosty, my friends. Take care and happy holidays.